Good afternoon. My name is PJ Conway, and I'm making this video to right a wrong. During this video, I'm going to address how my client, Jatar Washington's trial was not fair and impartial. There were things that could have been argued, including objections and the submission of evidence that was allowed as a result of fear of retaliation and an abusive process by authorities if I prevailed. I was in fear of winning at trial due to retaliation and a potential abuse of authority. With that pressure, there was no way I was in my right state of mind and focused on defending my client, Jatar Washington. I felt the investigation by the police was into his escape, and my alleged involvement was a tactic to keep me from winning and fighting trial to the best of my ability. And it worked because, as I stated once already, there were things I could have argued, but I did not. What follows is a further elaboration on what happened in this matter and why I believe it was unfair, prejudicial to my client, and why I believe justice was not served and something needs to be done. As I said, my name is PJ Conway, and I'm an attorney in the state of Ohio. I was appointed to represent Jatar Washington in Miami County Common Pleas case number 2018 CR 374. There were numerous criminal charges. From the beginning of the case, it felt like the county had it out for him, Mr. Washington, based on how he was being treated by the court as well as the jail. It felt like they had already predetermined his guilt, and the trial was more of formality, more than formality than a protection of his rights. Throughout the course of the case, I filed numerous motions to protect Mr. Washington's rights. There was two motions for violation of his speedy trial rights. I believe that his speedy trial was violated, and what is interesting to note is even though the speedy trial is supposed to be done in favor of the defendant, the court, the prosecutor, and us had three different numbers as to what his time was, and we believe his speedy trial time was up. We also filed a motion to change venue based on the fact that he was getting unfair treatment from the court as well as the jail in this matter. We also filed numerous grievances against the jail based on his maltreatment in the jail, which included nutritional and medical, as well as dental needs, which eventually led to him being let out of house arrest to get his own dental procedures done on his own because the jail would not help him out. We also, in addition, lastly, we did file a motion for the judge to recuse herself in this matter because the judge was a prosecutor in a former case of Mr. Washington. We believe that was unfair. We asked her to recuse herself on her own. She did not. We made a filing with the Supreme Court that was also denied. This case went on from August of 2019 until November of 2020. The trial was continued a couple different times. The evening before trial was to commence, I was notified that I was now part of a criminal investigation that involved escape charges filed against Mr. Washington. This is interesting as Mr. Washington had already pled guilty on those charges and there was no pending charges. There was no reason to bring a counsel into that other than a tactic to deal with the trial. Counsel discovered that Mr. Washington had been questioned about my involvement in the circumstances surrounding his escape charges in the week leading up to the jury trial. The undersigned counsel had contacted the detective about this matter, and he was told it was an open investigation. What's ironic is that same detective was a detective in the felony cases that were set to go forward in November of 2020 against Mr. Washington. Due to this newly discovered information, I moved to withdraw as counsel for the defendant. This information made it impossible to fully represent Mr. Washington and put aside the conflict of interest in his representation versus the potential case against me and the lack of focus that would entail. The pending investigation and the potential for defendant and counsel to be co-defendants was clearly a conflict of interest. In addition, defendant was potentially a witness against counsel, which further complicated matters and further exacerbated the conflict of interest between the defendant and his counsel. A conflict of interest clearly existed. The fact that the defendant and the counsel were possibly co-defendants in another matter severely clouded the attorney-client relationship due to the fact that the pending criminal investigation could have negatively impacted counsel's employment and everyday life. This conflict of interest went to the heart of this matter, in that how could we trust each other, being me and the defendant, knowing that we could be co-defendants in a case where one of us could be asked to testify against the other one. This was clearly a tactic to cloud up the trial process. This also affected counsel's ability to focus, and again, as I said previously, led to objections that not being made and evidentiary arguments that were not also made. There was no way counsel should have been expected to continue to represent the defendant in this matter, as there was clearly a conflict between counsel representing the defendant zealously on the one hand, and being subject to a criminal investigation that included his client on the other hand. This affected my performance as counsel in this matter and negatively affected my ability to represent the defendant. Defendant could have been a witness against me, as I said. There was no disclosure of what defendant communicated to the police, nor what the police asked the defendant about with regard to this matter. In addition, this questioning was done despite the fact that Mr. Washington was represented by counsel, yet they did not ask counsel to talk to Mr. Washington. No attorney would be able to continue to fully represent a client he could possibly be a co-defendant with when the matter was hanging over both defendant and counsel while the trial was proceeding. It led to a feeling, if successful at trial, that it would have led to a continued investigation and potential charges against counsel. It seemed like if defendant prevailed at trial, then the investigation would have continued forward against counsel. This issue affected the overall ability to represent Mr. Washington, as the whole case was clouded with the newly discovered pending investigation, and led to a lack of focus and a lack of even wanting to represent him with regard to that hanging over his head. Despite these facts and this motion being filed before trial, the court did not hold a hearing on the matter. They decided that even if a conflict existed, it was not related to this case. But I don't know how the court expected counsel and or the defendant, for that matter, to put aside, on the one hand, the representation in this case, and on the other hand, the potential to be against each other in another case. It's clear that the jury also probably witnessed the tension between counsel and his client throughout the trial. However, despite this clear conflict and despite the clear violation of Mr. Washington's constitutional rights, the state wanted the matter to proceed forward the day of trial, no matter what obstacle was in the way, and with no concern for his constitutional rights. The trial was commencing no matter what the issue was. There was no stopping or delaying the matter, despite its negative effect on defendant's right to a fair and impartial trial. In fact, this matter was appealed, and in a dissenting decision, one of the judges did say that there should have been more of a hearing, as this conflict did go to the heart of the representation of the attorney-client representation. This conflict had a negative effect on defendant's constitutional right to counsel. This was more than a mere strategy or communication issue. The issue went to the heart of the attorney-client relationship and had a negative impact on that, which was clear in the results of trial. With everything going on as set forth above, the court and the investigation made it feel like it was either him or me. And what that means is that if I prevailed at trial, then the investigation would definitely keep going forward. As I said in the beginning, the county seemed to be out to get Mr. Washington, and it was predetermined that he was guilty. I felt either if I win at trial, now I got to deal with that. If I don't, then hopefully everything would go away. Due to the foregoing, I was not fully focused at trial, as such investigation was pending and hanging over the whole situation. Again, I have made this video because I believe that my client was treated unfairly. I believe that he was not given a proper, fair trial. I believe that everything was done to make his trial not be fair. I believe that the attorney-client relationship was tainted, and I believe that this led to the results that occurred. As I said, there were certain things that could have been done. There was certain objections that could have been made, certain evidence that we could have stopped from being submitted or submitted on our own. and there was a fear that of retaliation if successful at trial, and or an abuse of discretion to go after counsel further if something happened that wasn't planned by the county or the state of Ohio. If you need anything further, please feel free to contact me. Thank you.